on this morning's Ag Issues program. A pleasure, as always, to bring to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
All right, let's get to it. And I'm sure it's probably an understatement to say that whether it's at presentations via email, you always get a lot of questions asked of you as well. And I think this is one you could probably put in that category. And that, of course, is about deducting residual soil fertility, or in this case, excess soil fertility. But the question that you pose and that you had on a recent blog is, does that concept apply to pasture and rangeland?
Yeah, Greg, you're right. I do get a lot of questions, and for those that are listening for which they haven't received an answer in a timely manner, I apologize. It's getting very difficult for me to keep up with things, but I do try to get response back to all of them. This is an issue that's been around for quite some time, and IRS 30 years ago gave us some guidance. Now, there's not much guidance, but they gave us two things. One was a technical advice memorandum, which is an internal document inside IRS where there's an IRS agent that's looking at a return under audit, and they don't know how to treat an issue on a return. So they ask the National Office of IRS to give guidance. And so the National Office will issue what's known as a technical advice memorandum back to that agent. Well, because of litigation back in the 80s, those now become public about 3 or 4 months after they're issued to the agent. So the rest of us can see kind of this internal agency thought process in these memos that the agency puts out to its own people. And one of those 30 years ago dealt with this issue of deducting excess soil fertility. And it ties back to a code section. The Section 180 of the Internal Revenue Code does allow a farmer, somebody that's engaged in the trader business of farming, to make an annual election by taking the deduction on the return of the cost of fertilizer and lime and potash and other minerals which will enrich or neutralize or condition that land that's used in farming. Well, if you don't expense those costs, then you have to capitalize those amounts. You add them to your basis in your land. Well, then the thought process was, well, what if I buy a farm and the previous owner has put all of these soil conditioners, let's call them in general, on the soil, and there's a buildup of excess over what's normal in the area? Can I write that off as the purchaser? Can I amortize that over the useful life of that excess amount, which is typically 3 to 4 years? Well, the IRS set forth in another document, another internal document, kind of a guide to their field agents as to how this can be done. So there's a right way to do this, there's a wrong way to do it, but we know the approach that the IRS wants us to follow on this for deduction on the federal return. That kind of opened up this whole industry of deducting residual or excess soil fertility. And it is a big issue, Greg. If I buy a farm that's $20,000 per acre, and there was one that sold just to the east of where I'm from last month, right at $20,000 per acre, just a shade under that, and it was all cash. So you can imagine rolling out the hundreds and the 500s and the 10s and the 20s for that. It was all a cash deal on the table, which tells you who the buyers were in that instance. But if I'm buying a farm for $20,000 an acre, and there's been a lot of these sales, for example, in Iowa, and I've got an excess buildup of soil fertility, I want to write that off. In fact, I want to allocate as much of that purchase price to depreciable items as I possibly can, and take a deduction to effectively lower my purchase price. And I've seen some of these, particularly in Iowa, where you'll get they're claiming. I'm not saying it's going to wash with IRS, but the audit rate is so low. That's another story. But I've seen some of these be 30% of the purchase price. So that's on a $20,000 per acre farm. That's $6,000 per acre of that purchase price that I'm allocating to residual fertilizer supply. So it's a big deal. Well, of course, you have to hire an agronomist or an agronomic firm that does the soil analysis. You have to hire them to come out and take soil samples to measure and quantify the amount of any excess compared to the average in the area, and then get their opinion, their professional opinion of how long that will last so that your tax professional can set it up and amortize that for you over that useful life. So that's the process that has to be done, and there's a lot of documentation, as you can imagine, that goes along with this. Well, what's happened recently, and the reason I put this blog article together, I've been talking about this at my seminars for years, but recently I have been getting questions over the past several months about whether this can apply to pasture land, rangeland, native grassland. And in theory, Greg, the answer is yes, but the application's a little bit different.
And as far as the application is concerned, what makes it different, or what makes it a little different, as you stated?
Well, the application is different simply because the soil is different. Your starting point is the same. We start with Section 180, and 180 does say, yes, it can apply to ground that is used to sustain livestock. That's the language in the code, sustenance of livestock. Okay, that would mean pasture land, rangeland, perhaps native grassland. But when you talk about the application of that, we don't have the same soil fertility buildup in pasture land or rangeland that we do in cropland. Your nitrogen levels are much less. Your phosphorus levels are less. And so your buildup, if any, is going to be pretty small. Plus, we're starting with a lower fair market value amount on the land to begin with. And so your deduction from that starting point is going to be lower than compared to crop ground. So when you hire the firm to do the analysis, you get all this work done, you pay for that, of course, to get a lower deduction on ground that will have probably nowhere near the amount you could claim on crop ground. I just don't think the economics of it are going to be there in many instances. What we do in the Flint Hills to build up that pasture ground is we burn it. That's how you get unwanted species set back for the year. We don't normally put additional soil conditioners on pasture ground. Occasionally that might happen, but what I'm saying is the application's just not going to be there as in terms of this code section, this provision involving excess soil fertility, as it would be with crop ground. So while some of these firms are doing a lot of heavy marketing on this, I think the warning here is, you better have your antennae up. Just be careful with respect to this if you're going to apply it to other than crop ground.
So let's just say farmland is acquired. How does the allocation of value? How does that how that can be made, and how is that value looked at as far as on depreciable items? Then,
well, anytime we buy a farm, we want to try to allocate as much value of that purchase price and as much of that dollar amount to items that are depreciable. So if we've got fences, we want to make an allocation to fences. And we've got some rule of thumbs in the trade as to how much we can allocate to good fences. Now, if it's an old dilapidated fence, that we're not going to allocate any purchase price to that and depreciate it because it doesn't have any use. But if I've got good fences, if I've got grain storage facility, if I've got farm buildings, if I've got, say I'm in Iowa or Indiana or Illinois, I've got drainage tiles, then I'm going to allocate part of the purchase price to that. If I've got road access, we can put a value on that and allocate a certain amount of the purchase price to road access, for example. So there are a number of things that we can do. And when it comes to soil fertility, that's just another thing. If we can measure it and there is an excess, we'll allocate value to it. Now, another approach on this might be to do and I don't mention this in the blog article because I'm just not comfortable with it being viable economically, and that's a segregation cost study. So if you do a cost segregation study, then that might be one way to come up with an allocation to soil fertility. But that's a different approach that kind of is the same thing.
And can this vary state by state as far as how this is interpreted, or what, depending on what state you're in, on what you may need to do?
Yeah, it certainly can. What I'm talking about so far has been on the federal return, but when it comes to the state return, some states just simply will not allow a deduction for excess soil fertility, Minnesota being one of those. The Minnesota Department of Revenue just will not allow this, period, on the state return. Not every state is like that. In some states, of course, if they couple with the feds on tax policy, then theoretically it should be utilized. But there are some nuances from state to state where you're not going to be able to get the deduction on the state return, but you could take it on the federal return.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest on the program this morning. And this one, Roger, we go up to Minnesota as far as the case is concerned, but it is about equity theft. And you pose the question, can I lose my farm for failure to pay property taxes?
Yeah, Greg, and this is an issue that's before the U.S. Supreme Court right now. This Minnesota case has made it all the way to the U.S. Supreme Court. The court has decided to hear the case, and we should have a decision relatively soon on this as things go in the Supreme Court. But this is a big issue, and what happened here is what every state provides. If you don't pay your property taxes on your home or on your farmland, then ultimately, through the end of a long process, the home or the land can be forfeited, and then the state will sell it at auction and bag the proceeds. Now, the question is, if I have a lot of equity in my home compared to my tax debt, let's say I have, let's take the situation in the Minnesota case. This is an elderly lady. She's in her at the time of the case, was in her mid-90s. She had a condominium. Situation in Minnesota deteriorated such that it wasn't safe for her to stay in her condominium, so she moves to an apartment in a safer place in the Minneapolis area, and didn't pay the taxes on her condominium. They didn't get paid, so it goes through the forfeiture process, the redemption process. This takes a period of time, and it could take 3 years is the typical redemption process as you go all the way through it in many states. And there's some extra protections for farmland, but it gets all the way to the end, and the property her condo is sold, and there's a $25,000 excess. Well, that represented her equity. You would think, well, once the county, in this instance, recovers the amount of tax debt that she owed, then the balance would come to her. No, they kept it. And this has been happening all over the country, and it's become, in fact, basically a cottage industry for the state of Massachusetts, picking up millions upon millions of dollars every year in retaining home equity and then using it for other purposes. There was a case in Nebraska involving a 480-acre farm just a little bit southeast of North Platte a few years ago, and that farm was worth $1.1 million, and the tax debt was much, much lower than that. It was only $50,000 in delinquent taxes. And the landowner, again, an elderly lady, she ends up in a nursing home. Her son has power of attorney. He delegates that to or assigns that to a bank. And in the process of things, the bank didn't know that the property taxes need to be paid. The son assumed that the bank was paying the property taxes. That farm gets sold. It's $1.1 million to pay a $50,000 tax debt. And the court said, well, yeah, they followed the process. Now, there was a stinging dissent in that case that said that was a windfall that borders on the obscene. But this is happening all over the country. And so I raised the question, can I lose my farm for failure to pay taxes? The answer, of course, to that is yes, the states can do this. The question before the Supreme Court is, well, can the states retain the equity that you have in your farm? And there are 12 states that allow the government to keep the proceeds of sale. In addition to Minnesota, the full proceeds of a sale. In addition to Minnesota, it's Alabama, Arizona, Colorado, Illinois, Maine, Massachusetts, Nebraska, New Jersey, New York, South Dakota, and Oregon. Kansas has some statutory protections in place where the state can't retain the equity. But the question on this is, for those states that do that, isn't that an unconstitutional taking of private property that violates the Fifth Amendment? Also, is it an excessive fine? You think of a $1.1 million farm that's lost to pay a $50,000 tax debt, and you lose your equity in that. some would say that probably is an excessive fine. So we'll see what the Supreme Court says on that.
And you talked about that Nebraska case. Remember, Nebraska is a unicameral legislation,
Mm-hmm.
so in other words, one house. Did they? I understand they changed some requirements as well for the service of notice when applying for the tax deed.
They did. They really did. They changed the Nebraska provisions about service of notice and really are dealing with this issue on the service of notice issue when you have an owner that is of impaired mental condition, which the lady in this instance was. She was in a nursing home. She had an impaired mental condition, and in Nebraska, that's supposed to extend the statute to 5 years instead of 3. In other words, you've got 5 years to come to get your tax debt paid. But it really changes the rules and makes it more difficult for a situation like this to happen again. So the legislature reacted, but again, that's after the fact. And so it was of no help to that particular situation. But this is a big issue, and it's happening all over the country as states find budgets tight. This is just another way for them to get their hands on some additional money. So we'll see if the Supreme Court says this is a constitutional violation to keep all that equity.
Roger, a couple more things, and it may not be the next time that we talk on March 20th, but we're getting closer and closer to, well, we hope we're getting closer and closer that the Supreme Court will have their decisions handed down, specifically Sackett v. EPA, and also potentially as far as the Renewable Fuel Standards, the RVO, is concerned.
Well, that and Proposition 12, also the California case. So there's some 3 big ones that are out there. If I'm reading the tea leaves right, I think we get Sackett first. I think that one would come up first. But you never know. They can throw these things out of order. But the way I look at the lineup, I think we'll get the WOTUS decision first, and then probably Prop 12, and then maybe the EPA refiner issue after that.
All right. Sounds good. And Roger, they can go to your blog as well to read more about the discussions that we had today.
That's right. Either my blog on washburnlaw.edu/Walter, WALTR, or on K-State's Ag Manager website.
All right. Sounds good. Roger, as always, appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he has been our guest this morning on the Ag Issues program here on 580 WIBW.